So thanks for having me on, Natalie. Both of these cases are big wins. Before I describe something, look, we get so much bad news, right? We have this massive electric car mandate coming in from EPA. They're going to require this unproven technology, carbon capture and sequestration, as a way of driving up your electricity bills. You got them trying to cancel your gas stoves. You have the SEC that's going to require climate disclosures. Everybody's in on the act of climate hysteria. And our one bulwark is the Supreme Court. So when we have victories in that area, we do have to celebrate them. So we got two of them. And let me cover the first one, which I think is really accessible, which is about the takings clause of the Constitution, the part of the Constitution that says that your property cannot be taken for public use without just compensation. So we're talking about a little old lady, who's 94 years old in Hennepin County, Minnesota. And she owes, back taxes. And then because they keep stacking on penalties and interest, it builds up to $15,000. She's got a $40,000 home. And what do? They come in and they take the home and sell it, and they keep the $25,000 surplus. And they say, nothing to see here. We get to keep this because once we've taken the property, we have absolute title. We're just going to, shoot those funds over to general government purposes, some for education and the like. And so, of course, she challenges this, goes all the way to the Supreme Court. And the Supreme Court said, no, that was a taking. They can, take the money that she owed in the back taxes, but they can't take the full amount and steal that from her, essentially. As Chief Justice Roberts wrote for a unanimous court, you have to pay unto Caesar, what is his due, but no more than his due. And so I think this is a good development for the Republic, both because the takings clause in many ways has been in decline since the start of the Republic, and it's especially been in decline in an area where regulatory agencies like EPA and others impose regulations on you that radically reduce your property values, and then they try to claim that there's no taking owed. So it's good to see here that there was a pushback on this confiscation of Ms. Tyler's property, and that I think it's going to be a useful precedent to build on for future fights against the regulatory state, Natalie. So that's that decision. The second decision involves the Clean Water Act and the whole issue of protecting wetlands and how they're regulated. It turns out that the jurisdiction that EPA and the Army Corps of Engineers, it's a strange regime where both of those agencies have jurisdiction, that they have jurisdiction over the waters of the United States, but there's always been a fight about, well, what does that term mean exactly? I think it really originally was intended to mean the navigable waters, but it's expanded past that. But it clearly has to be, some kind of traditional water that you would recognize as such, not a damp patch in your backyard, not a vernal pool. And I have been working on this issue for more than 20 years, going back to like 1999, 2000, before I joined the Justice Department the first time. And there was a case that went to the Supreme Court that was truly ridiculous and caused the Supreme Court to push back on this overregulation. And it involved the Army Corps of Engineers having an interpretation of the Clean Water Act that said they can regulate your wetlands if a migratory bird lands on the wetlands. So it doesn't have to be a river, a lake, a stream. It can just be a damp patch, and if migratory birds use it, then there's federal jurisdiction. And that was super radical. The Supreme Court struck that down, said that posed serious problems under the Commerce Clause power, because it's state and localities that have powers to regulate land generally, not the federal government. The federal government can regulate waters, but not land. And on the Army Corps' interpretation, they basically had converted it into, we can regulate a lot of things that Congress never intended. And then I think the decision, it was a case called Swank, invited the EPA and the Army Corps of Engineers to fix the statute. And so then I, came into the Bush 43 administration. I worked, tirelessly on trying to fix the statute to get something like we got from the Supreme Court yesterday. And, here's a, funny little story. This environmental group called, I'm blanking on the name of it. They called up, Ducks Unlimited. They called up President Bush and they said, don't change this regulatory regime, keep more wetlands in federal jurisdiction, and he pulled the plug on the fight. So then the Supreme Court had to weigh in again, and they split badly with 4 justices led by Scalia saying, hey, you cannot regulate wetlands unless, there's something like a traditional waterway involved. And Justice Kennedy was squishier, and he said you can regulate wetlands if they have a significant nexus, which is just replicating the weird problem of what exactly is a wetland that you have jurisdiction over. So finally, after a lot of falderall, there's a couple who just want to build a home out in California, and there's not a traditional water there. There's just a ditch, and they are blocked from building on their home. And the Supreme Court finally stepped forward, and seeing that the political branch, the executive branch, wasn't doing the job with the regulations, they came in and they clearly said that EPA was massively overreaching and trying to say that these were wetlands that could block this, new home for the plaintiffs, and that this is a massive victory for the against the administrative state, against the deep state, Natalie, because it's giving power back to private individuals for control over their own property. So it shares a lot with the Tyler case, because that's also saying that if the government does overreach and actually grab your property and sell off the surplus, that's unconstitutional. So those are the 2 cases.
I don't think the administrative state has ever seen a drop of water, an inch of land, a branch of a tree that they haven't wanted to regulate or get involved with. That is, unless it is in East Palestine, Ohio. So before I let you go, if you could give the War Room Posse just a bit of an update on what the latest is with that whole tragedy, the action or inaction that we've seen out of the Biden DOJ on that front.
I don't think that I've seen any major developments, Natalie. I think the litigation continues to grind along, and the Norfolk Southern is facing a torrent of private litigation and putative class actions. They're also facing this, suit from EPA, which, I think there should be much more done for the residents of East Palestine by EPA and by the federal government generally. We still have President Biden, who's on world travel tours, Ireland, Japan, et cetera, but he can't bestir himself to go out and talk to the residents who were injured by a completely stupid decision to do a controlled burn, which was really an uncontrolled burn of vinyl chloride, which creates phosgene gas. He cannot go out there, even after all this time. They keep saying, he might go at some point, but it never seems to wind up on his schedule. It's very sad. And then on the Josh Shapiro front, I'm not seeing any real movement there in trying to hold Norfolk Southern accountable. So maybe he just had a press conference and now he's dusted his hands of it.